Hey, let's spend a couple of minutes talking about one of the most important exceptions to Washington's self-defense law, and of course that would be the First Aggressor Standard here in Washington. We talk oftentimes about what the law gives us the right to do, but we don't talk frequently enough about the things we can do that will preclude us from otherwise using the law to protect us. One of the most important things when it comes to the act of self-defense is the First Aggressor Standard. Now, the First Aggressor Standard, much like the no duty to retreat, is not found in a statute. You will find no statute anywhere in the RCW that talks about the First Aggressor Standard. You will, however, find a litany of case law that talks about it. And what it basically says is this, is that if you are the one who provokes the fight, if you're the one that picks the fight, you don't later get to claim self-defense. Now, the only exception is if while you may pick the fight, if you then withdraw and you do so in a manner that demonstrates to every reasonable person around, including the would-be perpetrator, that you are in fact withdrawing from combat, and they continue after you, then and only then might you be able to avail yourself of self-defense. Now, how important is the First Aggressor Standard? Well, we have seen this applied in two very high-profile cases in the last 12 months. One, of course, being Kyle Rittenhouse, where the prosecution attempted, quite futilely, to argue that Mr. Rittenhouse's mere presence on the Kenosha streets was the act of first aggression, and therefore he could not use self-defense. Nice try. The other one was the McMichaels attorney in the Ahmaud Arbery case, who tried to claim that Mr. Arbery was the first aggressor when he decided to turn around and try to wrestle the shotgun away from Mr. McMichael. The jury there also got it right when they said, no, when you guys piled into that pickup truck and went chasing after that kid with your guns, that was the act of first aggression. So the bottom line is this. You got to be careful about who you run around with. You got to be careful, especially when you're carrying, who you're associating with. Because if you are, in fact, determined to be the instigator of the conflict, that is, you are the one that picks the fight, you likely could be held accountable under the First Aggressor Standard, and therefore, you do not have a lawful right of self-defense. For a more thorough discussion on this topic, go ahead and visit us over at our YouTube channel. My name is William Kirk. I'm the president of Washington Gun Law, and you have been watching Bullet Points.